So good afternoon, everybody. My name's Charles Irvine, and I practice at 3PB, where I am the Deputy Head of Chambers Property and Estates team. And I'm pleased to be speaking about the Renters' Rights Bill, which replaced the Tory government's Renters' Reform Bill, with Conor, Maher, a Senior Associate Solicitor in Dispute Resolution at Ellis Jones. And as you can see on this slide, he is ranked in Legal 500, and I can embarrass him by showing you all the wonderful directory quotes about how amazing he is.
Thanks, Charles. It would have been incredibly gauche of me to have intentionally made sure you put both 2024 and 2025 into the presentation, but I know you've humbly included your own quotes as well, so I say we're even on that.
True. But equally, I don't think people have necessarily joined to hear us compliment each other. I should just say that if you have any questions as we go along, please put those into the Q&A function at the bottom of the screen rather than the chat, and we'll try and answer as many as we can at the end of this session. We should hopefully be talking for just shy of an hour, probably about 45 minutes, 50 minutes. So we should have time for questions at the end. Conor, should we kick off by going through a quick recap of the Tories' Renters' Reform Bill before looking at what Labour have added to their Renters' Rights Bill, which, unsurprisingly for a left-of-centre government, has shifted from reform for renters to rights for renters?
Sure, absolutely. So purpose of the talk today is to inform and update landlords, letting agents and those who are advising them about the key provisions and planned changes really of the new Renters' Rights Bill. So what we're going to be talking about are the key changes, as you've mentioned, from the previous Tory bill. We're going to talk about the abolition of fixed-term tenancies and the abolition of Section 21, reform of Section 8 and grounds for possession and what they might be under the new bill, looking at stating rent and rent bidding, and looking at how we're going to be able to increase rent during the life of a tenancy, as well as the oft-mentioned provisions as to pets and discrimination, looking at the private rental sector database that's going to be imposed, as well as the Ombudsman Redress Scheme, looking at AWAB's law in terms of decent home standards, and then finishing off with some advice and top tips for both landlords, letting agents, and also those who advise them legally in terms of preparing for implementation. Now, as I said, firstly, we're going to look at comparing the Labour government's Renters' Rights Bill to the previous Conservative government's Renters' Reform Bill. Now, the clue's in the name, essentially. The previous bill was designed to reform. The new bill is designed to increase the scope and extent of the rights for tenants. Bottom line up front is that the Renters' Rights Bill includes a majority of the key provisions of its previous incarnation. And so the drafting simply expands and increases the protections, whilst removing some of the tougher, landlord-friendly provisions of the previous bill and including some additional tenant protections. So first thing to consider is what's staying. Well, fixed-term tenancies are gone, assured and short-hard tenancies are gone. There are new Section 8 grounds for possession, which were in the previous incarnation, which are in the new one. The compulsory ombudsman scheme, the redress scheme, is staying from the previous bill into the new. There will be the same, or near as damn it, same statutory procedure for rent increases in the old bill as the new bill. The right to keep a pet is staying, as well as the prohibition on discrimination for those on benefits and with children. And the financial penalties, the civil fines for breaches of the Protection from Eviction Act 1977 are staying as well. But probably more interesting than what's staying is what's going. So the only major provision which is missing from the new bill as opposed to the old, for our purposes today, was the rather tough and overtly pro-landlord proposed mandatory ground A for possession. Now, those who have been to talks before with either Charles or I will probably remember that under the previous bill, landlords could obtain a mandatory possession order under ground new 8, ground 8A, if the tenant were to drop into 2 months' worth of a rent arrears 3 times or more within a 3-year period. So that's any 3-year period. So that ground that was proposed under 8A covered far more than the persistent rent arrears grounds that exists in the current legislation, and was considered by many as quite a tough piece of drafting. Now, the idea of that ground A was quite noble, and it was to avoid the rather laughable position that we have under the current legislation, where a tenant who's in persistent arrears can bring the arrears below 2 months arrears by £1 on the day of court, and thus avoid a mandatory possession order. Now, tenants will be very glad to hear that this ground is out, and it's straight out with not even lip service at replacement. So we're back to rent arrears possession as mandatory, and the old position of persistent rent arrears for a discretionary possession order. The other key change as to what's out, which will negatively impact on landlords, is the abandonment of the Conservative government's planned court reform criteria. So, in essence, the previous bill was proposed to be contingent and would not be brought into force even after it's been passed into law and received royal assent, until the Secretary of State for Housing, Communities and Local Government received a report from the Lord Chancellor and Justice Secretary, which essentially confirmed that there had been significant and substantial court reform to clear the backlogs and improve the efficiency of the residential possession scape. Now that's gone. So the implementation and commencement of the operative provisions about Section 21 and Section 8 reform will not be waiting for court reform. So we can expect the current timescales, I would estimate, of, so at the moment we're looking at maybe 8 to 12 weeks for a possession hearing in around this kind of area, so in around the Bournemouth area, but that can be double, if not triple sometimes in London. That's going to increase because and that's not really the fault of HMCTS or the Ministry of Justice. It's because the abolition of Section 21 will take with it the hearing-free accelerated possession route. And so every claim will now have to go to a hearing. And unless CPR reform is brought in to combat any backlog caused by, one, the influx of Section 21s, which are going to be coming in between now and commencement, but also the influx of Section 8s post-commencement, there will be delays in court process, unfortunately. Charles, did you want to take us through the reform of Section 21 and fixed-term tenancies?
Yeah. So, Conor, as you just mentioned, the Renters Reform Bill is intended to remove fixed-term tenancies, and so Section 21 notices associated with the end of an assured short-hold tenancy will similarly get abolished. So the objective of the legislation is to shift away from ASTs and provide more flexibility to tenants to allow them to change, to adapt to the changes in their lives more quickly. So the move from set length ASTs to month assured tenancies means that Section 21 notices are now defunct, as there is no fixed end to the tenancy. Further, there's kind of even more protection towards tenants rather than landlords under the proposed bill, because tenants will have a 12-month protected period at the beginning of the tenancy. And during that kind of 12-month period, landlords cannot evict a tenant if they have the intention of selling the property or moving into the property themselves. And even after the kind of protected period ends, a landlord is now required to give 4 months notice prior to commencing proceedings, rather than the 2 months that they're previously required to provide. The removal of the Section 21 notices will therefore have a marked impact on landlords who want to regain possession for any financial or personal reasons. And as we mentioned before, the kind of previous bill was designed to have this phased approach to change. But the current bill, so the Labour bill, intends an immediate abolishment of all existing ASTs and will affect all new tenancies moving forward. So the date of commencement, that is it. It's a cliff edge date. Conor, you mentioned a moment ago about the influx of claims coming in through the court. And I think that's a real issue, which we will find as practitioners, and certainly for landlords, the existing waiting times are just going to get even longer, certainly in the short term. There is a further blow to landlords in that the new bill does not prevent a tenant from submitting their 2 months notice to vacate within the first 4 months of a tenancy starting. So under the Renters Reform Bill, a tenant could put in their notice on day 1 of the tenancy. So in essence, creating a 2-month term. So all of these changes taken together make it easier for the tenant to move out, but harder for a landlord to make them do so. Conor, do you want to run through the new Section 8 grounds?
Sure. So although we're losing Section 21, the kind of carrot and stick for this is that the bill does propose that we're going to have amended and increased provisions and protections under Section 8 in order to get tenants out. So what we're going to do here is go through the key changes for the private rented sector. So we're focusing on the things that are going to be really important for private landlords and private letting agents. So looking firstly at the amended ground 1. So it's not really an amended ground. It says it's an amendment, but it's actually a complete replacement of the old ground 1 with a new one. Now, so historically, ground 1 was used where a landlord or their spouse had previously occupied the property as their principal home, had given notice to the tenant prior to commencement of the tenancy that was the case and that they may want to move back in, and then the landlord or their spouse would then sought possession of the property to use it once again as their principal home. Now, the new ground 1 or the amended ground 1 does the same thing, but possession can be for the landlord to move in or any of their family. So that includes, in this iteration, children, grandchildren, grandparents, siblings, half brothers, half sisters, all of that kind of stuff is now expanded to include them as well as simply the landlord and their spouse. Now, additionally, there is no longer any need for the landlord or their family to have ever lived in the property before the tenancy, nor is there any need for the notice to have been given prior to the tenancy commencing. So it's relaxing the requirements somewhat on getting possession back of the property in order for the landlord or their family to move in. But this ground can only be used, as Charles has rightly pointed out, where the Section 8 notice expires, so that the relevant date is after the 12 months from the commencement of the tenancy. So there's a 12-month protected period where you can't evict somebody under ground 1, so the first year of the tenancy. Now, that is up from 6 months from the previous bill. So it's doubled the protection of the tenancy from the Conservative bill. And as Charles mentioned also, that amended ground 1 will require 4 months notice, which is up from 2 under the previous bill and 2 under the current legislation. So not only are we going to have to give them 12 months protected, but we also are going to have to give them 4 months notice before we utilise ground 1 in order to obtain possession. Now, ground 1A is a hotly anticipated ground, which essentially seeks to replace much of the current logic and reasoning behind the Section 21 process. So a lot of landlords, not all, but I would say the majority, are using Section 21 to obtain possession on a no-fault basis currently to enable them to sell the property with vacant possession. And this is essentially what the new ground 1A is allowing them to do. Now, for this new ground to bite, the landlord must be intending to sell the property or grant a long lease of 21 years or more. This ground can only be used, again, similar to ground 1, where the Section 8 notice period expires, i.e. the relevant date is after 12 months from the commencement of the tenancy, so not in the first year. And the only exception to that is where the property is subject to a compulsory purchase by a relevant authority. Again, this 12-month period is up from 6 months under the previous bill. Now, new ground 1A, as with ground 1, will require 4 months notice, which is up from 2 under the previous bill. Moving on to talk about ground 6. So this is an often used ground for property developers and is the ground for redevelopment, reconstruction, demolition, etc. Now, in essence, ground 6 will remain as it is currently in the legislation, with the addition of a provision which prohibits its use within the first 6 months of the tenancy. So now, under the current legislation, you can use ground 6 to get possession at any time if you want to redevelop the property. Under the previous bill and this bill are exactly the same, which you can't use it in the first 6 months. And the exception there, as previously, is a compulsory purchase. Now, the amended ground 6 will also require 4 months notice. There's a bit of a theme here, which is up from 2 months under the previous bill and up from 2 months under the current legislation. Now, the one that is probably most important for most landlord clients is ground 8. So ground 8 is being amended and it is being increased so that whereas at the moment under the current legislation, you can serve a Section 8 notice if the tenant is in arrears of at least 2 months, presuming that they pay monthly. That is going to increase to 3 months. Which means that a landlord cannot obtain a mandatory order for possession unless the rent is unpaid for a minimum of 3 months and remains in arrears of at least 3 months at the existing key touch points. So that's at the time of the service of the Section 8 notice, at the time of issue of proceedings, and at the possession hearing itself. An additional key provision relates to universal credit, which was in the previous bill and is now in this bill, which essentially provides that if a tenant is eligible to be paid universal credit, then the amount of the arrears to be taken into consideration for the purposes of Ground 8 excludes any amount that is only in arrears, that is only unpaid, because the tenant hasn't yet been paid their universal credit. So if there are delays in DWP making the payments, or local authorities, housing authorities, etc., then that isn't to be held against the tenant. We can't obtain Section 8 mandatory possession on Ground 8 in that circumstance. Now, the amended Ground 8 will require 4 weeks' notice, which is up from 2 weeks currently and 2 weeks under the previous bill. So we're extending the amount of time that landlords are not getting paid for because we're having to wait for 3 months arrears. We're also then extending it by another 2 weeks as a kicker before you can issue proceedings following a Section 8 notice. Charles, did you want to take us through the student accommodation provisions?
Yeah, so this is new ground 4A, and this is for landlords of student lets, which is a useful and helpful replacement to Section 21 fixed term provisions, and it is essentially unamended from the previous bill. So ground 4A applies to student accommodation, i.e. an HMO, where all of the tenants meet the student test, i.e. being in full-time education. For ground 4A to be relied on, the landlord must give notice prior to the commencement of the tenancy. So before anyone moves in, you've got to give a notice saying that you may be in the future relying on ground 4A for possession. Landlords must also have the intention to relet the property in the new academic term to a new intake of tenants who also meet the student test. So for a Section 8 notice under ground 4A to be enforceable, the expiry of the notice period must fall within the summer holidays, so between the 1st of June and the 30th of September. The new ground 4A will, unsurprisingly, require 4 months notice, so tying in with Conor's theme that he mentioned earlier. And again, that's up from the 2 months notice under the previous bill and under the current legislation. This, perhaps more than most of the other grounds, impacts upon the efficacy of the ground. So student landlords would therefore be well advised to serve their precautionary Section 8 notices under ground 4A with the 4 months notice to expire on or after the 1st of June as a matter of course. And without it, new students wouldn't know whether or not they had an accommodation in advance of their studies, as landlords would be unable to seek possession of property in the way that they could in the past with ASTs, which would obviously cause chaos for students, landlords, and letting agents alike. I think we'll now just touch on some additional points about the Section 8 reforms and some other things that landlords and managing agents should be aware of. So there's now a direct, so if I can deal firstly with deposit protection and prescribed information, there is a direct relationship between relying on Section 8 grounds and the protection of tenancy deposits. I'm sure all of you are aware of tenancy deposit schemes, say My Deposits, the TDS and DPS schemes, and the fact that under the current system, a Section 8 ground could be relied on even if the deposit hasn't been properly protected. But under the bill, there are some kind of key changes here. So in particular, Section 25 of the bill, which is going to amend Sections 212 and 215 of the Housing Act regarding tenancy deposits. So protecting deposits will still be mandatory, and the compensation provisions, so the 3 times deposit provision, are remaining untouched. So those things still stand. But Section 215 is to be amended in respect of the consequences of not protecting a deposit or not giving the prescribed information at the start of a tenancy. So there will no longer be a once and for all breach. So if a landlord or their agent forgets to protect the deposit, they can protect it later and still serve a Section 8 notice, as long as the deposit is actually protected by the time that the Section 8 notice is served. And therefore, under the new bill, the tenancy deposit must be protected or repaid before a Section 8 notice can then be served and relied on. You may also wonder what's happened to EPCs, gas safety certificates, how to rent guides, etc. Those have been removed as direct requirements, but don't celebrate too soon. The reason that all of them have fallen out of this section is because they've moved on to the private rented sector database, which we will discuss later on. Conor, do you want to talk about notice periods?
Sure. Yeah. So as I mentioned earlier on, there have been some amendments to notice periods. So it's section 4, subsection 3E of the bill, which amends the standard notice period. So before we serve a Section 8 notice at all, we should be looking and making sure we're double checking that provision and the amended provision within the Housing Act to make sure that we're giving the right notice period. But in short, for all of the grounds that are going to be routinely relevant for the private rented sector and private landlords, the rule of thumb is going to be, if it was 2 months before, it's now 4 months. And if it was 4 weeks, if it was 2 weeks before, it's now 4 weeks. So it's essentially a doubling of the notice periods for the key ones that we will be looking at routinely in the private rented space. The other thing that I've kind of crowbarred into this slide, which isn't really relevant to Section 8, but is necessary to just give a bit of a health warning on anyway. So hopefully landlords, letting agents and those advising them will be fully aware that the Protection from Eviction Act 1977 makes it a criminal offence to unlawfully evict a tenant from a property and also to harass a tenant with the intention of them vacating the property. So threatening to evict them, turning off the water, turning off the gas, turning off the electric, changing locks, threatening to change locks. All of those things are criminal offences, and they are indictable criminal offences capable of being prosecuted in the Crown Court and potentially imprisonment. That stays the same. However, what the government is doing with this new bill, and to be fair, the Conservative government had planned to do previously, is to also make it possible for local authorities, instead of prosecuting this through the courts, to impose a civil financial penalty where people are breaching the Protection from Eviction Act, and impose a fine as opposed to taking them to court and prosecuting them through the civil space. Now, the financial penalty that local authorities are able to apply for every breach of the Protection from Eviction Act is up to £40,000. Which is up from £30,000 under the Conservative government's bill, but is still an extraordinarily hefty figure, especially for individual private landlords who might not know what they're doing is an offence necessarily. If they just say, "Go out of my property," a £40,000 fine landing in the post is not what everyone wants to receive. So really important that landlords are aware of what they can and can't do in terms of threatening the eviction, and not doing anything really if they're not 100% sure that they're not going to be in breach of the Protection from Eviction Act. So on that note, to carry on the doom and gloom, let's have a think about landlords' duties and what they might be. So sections 12 to 15 of the new bill impose additional duties which are going to be vitally important for both, for what the bill calls relevant persons. So that's landlords and their authorised agents. So it's not just landlords who have a legal obligation, it's anyone doing agency work for that landlord. So it will bite upon letting agents as well. So section 12 imposes a duty on landlords to give a written statement of terms to the tenant, as well as any other information which may in the future be prescribed by the Secretary of State. Now, we don't know what that is at the moment, but it will probably be things like the How to Rent Guide, Gas Safety Certificate, EPC, Electrical Conditioning Report, all of that good stuff that we already have as prescribed information. Section 13 also includes a lot of duties, which is what it calls them, but they're actually prohibitions. They're things that a landlord and a letting agent cannot do. So those are, for example, purporting to let a property on a fixed term. So if you tell your tenant, "Oh, this is a 12-month fixed term," it is not because of this bill. And if you say that you are letting it on a fixed term, that is a breach of duty under section 13. Purporting to end a tenancy by giving a notice to quit rather than a section 8 notice. And also purporting to end a tenancy or give notice orally, so not in writing, is a breach of duty. Serving a Section 8 notice or any notice for possession which doesn't comply with Section 8, so if you don't use the right form, you don't specify the grounds, you don't complete it properly, that is a breach of duty under Section 13. And importantly, and most importantly, if you serve a Section 8 notice and you specify a ground of possession, but you do not have a objectively reasonable belief that you are going to be able to obtain possession on that ground, that is a really significant breach of duty. So you can't simply whack a Section 8 notice out and hope for the best, because that will have significant consequences. Now, additionally, under Section 13, landlords and letting agents, when using grounds 1 and 1A, so that's landlord or family moving into the property or selling the property, have to be extremely careful about their conduct for 12 months after possession is obtained, which is what they're calling the restricted period. So in that 12-month period from possession, the landlord and letting agent must not let the property for a term of 21 years or less. So essentially what used to be a short hold tenancy or a short hold tenancy. They must not market the property to let for 21 years or less. They must not give a license to occupy, and they must not market the property for a license to occupy, and can't authorize anybody else to market the property for let or license. And marketing is defined as either advertising the property or telling people that you've got a property available for let or license. Now, why is that important? Well, Section 15 empowers the local authority, local housing authority specifically, to impose civil financial penalties upon both landlords and letting agents where there is a breach of any of those duties. So any of the breach of duties that I've mentioned, if that then results in the tenant leaving the property within 4 months of the breach, then the local authority can give a penalty of £7,000, which is up from £5,000 under the previous bill. So, for example, if you say when you let a property to someone, this is a 6-month tenancy, and it's not, it's a periodic tenancy by operation of law, that's potentially a financial penalty of £7,000. Equally, if you don't give them a Section 8 notice in the right form, that's potentially a penalty of £7,000. But also, more importantly, there is also an offence under Section 15, so it makes it a criminal offence for you to serve that Section 8, which on the grounds that you don't have reasonable belief are going to be successful. So if you have a landlord who serves a Section 8 notice because of 2 months rent arrears, because they haven't been to this webinar and they haven't heard Charles and I speak about the fact that it's now 3 months, not 2, that is not a reasonable belief, because ignorance is no excuse. And so that landlord would likely be committing a criminal offence under Section 15 of the Bill, soon to be Act. And that is a substantial criminal offence which will make them liable for potentially an unlimited fine in the magistrate's court on summary conviction. Now, just an additional health warning to make it even more unpalatable, Section 15 specifies that where the landlord or the letting agent are a corporate entity, not only will the body corporate be liable, so the landlord company or the letting agency will have a financial penalty imposed by the magistrate's court, but every director and member, so shareholder, who is complicit in the breach, who has authorised it or knows about it or is aware of it, will also be personally liable on a criminal basis for breaches. So it's quite important this is got right. And in addition, local housing authorities have the ability to impose a fine of up to £40,000, again, if there is a breach of that requirement not to give a Section 8 notice if you don't have a reasonable belief. So either they can prosecute you in the magistrate's court with an unlimited fine, or they can get you with a civil penalty of £40,000. So apologies that I'm not being very positive in terms of these landlord duties, but I think it's useful for us all to appreciate and understand the severity of what what is coming down the line, and making sure we plan and prepare for this. On a slightly less gloomy note, let's talk about rent and rent bidding. So under Section 55, landlords and their letting agents are prohibited from advertising a property to let without specifying the rent payable. So the proposed rent is what the bill is calling it. Equally, landlords and letting agents are also prohibited from inviting or encouraging anyone to pay rent above the proposed rent, and they're also prohibited from accepting payment of rent above the proposed rent. So, in short, you as a landlord or a letting agent needs to specify how much money you're willing to accept for the rental of the property. You're not allowed to ask for more, and if somebody offers you more, you're not allowed to take it. And if you do any of those things, Section 56 imposes a penalty, which, surprise, surprise, is £7,000. And that is against the landlord, the letting agent, as well as any directors or members of a corporate landlord or letting agent. And this is essentially to stop rental bidding wars, which are more common in London than they are in the regions. But it's important that letting agents, even outside of London, are aware of this new requirement that you must specify the proposed rent on the advert and you cannot go above it. Moving on to rent increases. So Section 7 of the bill introduces a procedure and mechanism for increasing rent, which essentially reforms and amends the existing procedure, which some of you may be aware of, under Section 13 of the 1988 Housing Act. Now, in short, what Section 7 provides is that rent can now only be reviewed annually, so once per year, and it can only be reviewed in accordance with the Section 13 procedure, regardless of what the parties have contractually agreed. So landlord has to serve a Section 13 notice proposing a rent increase. Rent review clauses are now therefore essentially defunct. They don't exist anymore. They're not going to be of any effect. Now, if a tenant considers the Section 13 notice and says that the rent is excessive, they can make an application to the first tier tribunal for a determination. Now, the key change from the previous legislation is that the first tier tribunal, the FTT, can only make a determination that the rent is the lower of either the market rent or the proposed rent. So there's no scope for the FTT to go outside of those figures and exercise discretion as they have previously. Now, importantly and strangely, in my view, this applies not only to proposed rent increases throughout the life of the tenancy, but it also applies to the initial rent under the tenancy. So where the tenant takes on a property, takes on a tenancy, agrees to pay a certain rent, the proposed rent, which you've marketed and put on the advert and not exceeded anything and not accepted anything in excess of, that tenant then decides in the first 6 months, actually, I think my rent is excessive. They can seek a determination from the FTT under the new bill that their rent is excessive, even though they've contractually agreed to it. And they could also do that with any proposed increases during the term of during the life, rather, not the term of the tenancy. And just as a side point for any lawyers dealing with this in the room is that the FTT will also have a new power to determine whether a notice under Section 13 is valid, which they can't currently do. So the validity of a Section 13 notice will become a hot issue in rent increase litigation before the FTT. The slightly less contentious, I would hope, points of pets and discrimination. So this has been on the cards in the last bill and is basically unchanged, but just to recap on the provisions to pets, Section 10 gives tenants the right to make a request to their landlord for permission to keep a pet at the property. The tenant must specify the nature of the pet, so what it is, and the landlord's consent cannot unreasonably be withheld. So that means that a landlord has to consider whether they can reasonably say no, and if in doubt, consent should be given. But if there is an objectively reasonable rationale for refusing the request, the landlord is free to do so. So, for example, if the request is for a poisonous snake or an illegally trafficked animal, a dangerous animal, or something wildly inappropriate like an elephant in a flat, that could be refused. But in practice, I would hasten to say refusals are probably going to be rare. I think it's more likely to be a dog, a cat, a hamster, which is probably going to be quite reasonable in almost all circumstances. Now, landlords can, under Section 11, require that the tenant, as a condition of the consent being provided, either takes out a policy of insurance for pet damage or pays the premiums of the policy to be taken out by the landlord. And it's useful to note under Section 10 that landlords are not compelled to grant permission for a pet where that consent would be in breach of a condition of a superior lease or a restrictive covenant. So there is no compulsion on superior landlords to allow inferior landlords to grant consent to for a pet, nor is there any requirement on the beneficiaries of restrictive covenants. So in that situation, a landlord can fully refuse consent, and he's able to do so without fear of repercussion. And just very briefly, as anticipated from the previous bill and essentially unamended, sections 32 to 41 prohibit landlords and their agents from discriminating against tenants and prospective tenants, in particular where those tenants are in receipt of housing benefit or where they have children. So it cannot, under any circumstances, be permissible for a landlord or a letting agent to say no to letting a property to someone because they're on benefits or they have children. And during the term of the tenancy, or during the life, I should say, rather, landlords cannot in any way discriminate against people for having benefits or having children, and that would be a breach of Chapter 3, and there are serious repercussions for that. Charles, do you want to take us into the glory of the private rented sector database?
You've given me all the fascinating topics, Conor. As expected, the government are introducing a private rented sector database. The database and the requirements of it will be imposed by regulations made by the Secretary of State. However, Section 80 of the bill makes it compulsory for landlords and their agents to register with the database every time that a property is either marketed, advertised, or let. Landlords must also themselves have an active registration with the database at all times when letting a property to a tenant on a residential basis. Conversely, or interestingly, there is no tenant database requirements. So there's no database offering assistance for landlords to find out information about prospective tenants. Importantly, under Section 88 of the bill, a landlord is prohibited from obtaining possession of a property under a Section 8 notice where they have not complied with all of the registration requirements under Section 80, i.e. jumping through the hoops of the private rented sector database. So while the principle of registration is not new in this bill, the bill is going to strengthen the enforcement of the requirements by imposing restrictions on gaining possession where there has been non-compliance. So despite disappearing from the Section 8 grounds themselves, it's still a requirement to include an EPC and gas safety certificate to gain possession. They've just sneakily moved them into the database requirements rather than other legislation. If a landlord or their agent fail to register the landlord with the database or fail to comply with the requirements to register the marketing, advertising, or letting under Section 80, lo and behold, there is a financial penalty, which you can probably guess the amount for that penalty, and it's going to be our favourite number, £7,000 per breach. Section 90 also makes it a criminal offence to give false or misleading information to the database. And again, a financial penalty at the top whack of £40,000 per offence, or a criminal prosecution and summary conviction, and unlimited financial penalty in the criminal courts. As Conor mentioned before, there is also the potential for corporate directors, etc., to be potentially personal liability for corporate bodies. There is currently no indication of how much it will cost to join the database, but the guidance to the bill says that landlords will be required to pay to register on it. So it's not going to be a free service. How well this system actually operates is yet to be seen. But if your experience is anything like mine, if it's anything to do with the government and IT, it will probably come in late, come in over cost, and it will always be your fault when something that was supposed to work doesn't end up working for you. There is also the landlord redress scheme, and Section 62 again provides that the Secretary of State will make regulations for the compulsory membership by landlords to an ombudsman/redress scheme. So the aim of the scheme will be to cover complaints made by prospective, current, and former tenants. And the bill compels landlords to be members of the scheme prior to marketing a letting or granting a tenancy. Section 64, again, imposes financial penalties that can be enforced by the local housing authority for, again, a fine of £7,000 per breach. And that would be a failure to register or comply with the Secretary of State's regulations as to this Ombudsman service. And similar to the database requirements, there's the criminal liability element and the corporate director personal liability issue as well. So the aim of the Ombudsman scheme is to provide a quick and cheap resolution for tenants only when there are disputes. So, i.e., it will not help you as a landlord. Obviously, this new system is in addition to the existing government-approved schemes that already handle complaints by tenants, such as those through the Property Ombudsman and the Property Redress Scheme. And in keeping with Labour government's principles, the only major change from the previous iteration of the bill is that massive hike in fines for landlords who don't join. So, moral of the story, join as soon as the Secretary of State gets the Ombudsman scheme up and running. If I can then just touch on Awab's law, which some people may be aware of, certainly if you deal with any social housing or you've got social housing tenants. So Awab's law was the result of the unfortunate death of 2-year-old Awab Ishaq from a mold-induced respiratory condition. And the law was introduced in the Social Housing Regulation Act 2023. So if you're unfamiliar with the Social Housing Regulation Act 2023, the highlights are that the Act requires landlords to make prompt investigations and remediation for damp and mold issues. And it also aims to prevent tenants from getting the blame for mold issues, and it takes a zero tolerance approach to mold. It's just unfortunate that mold exists in a damp country like ours. The law makes it clear that the landlord must investigate potential hazards within 14 calendar days of being made aware of the issue, and then provide a written summary of the investigation within 48 hours, setting out what the hazards were found and the intended next steps. Works then need to be completed 7 days thereafter, where you've got a significant health hazard, or within 24 hours if there is imminent danger. So what, in essence, the law requires is for landlords to complete repairs within a reasonable timescale whilst considering the tenant's needs. As a further incentive to landlords to act promptly, they also have to offer or arrange alternative accommodation at their own expense should the hazard not be dealt with fast enough. If we can then turn to the bill, so this is going to be in section 98 of the bill, and what it says is it's going to extend the application of decent home standards to the private rented sector as well as the social housing sector. And the Secretary of State is empowered to make regulations as to the standard and condition of homes and HMOs rented privately, and allow tenants to challenge dangerous conditions, i.e. mold and similar types of things, and compel landlords to remedy issues and impose financial penalties for non-compliance. Section 98 will operate unusually as an implied term into the tenancy agreement. So if a landlord is in breach of the decent home standard and fails to remedy issues, for example, by failing to remedy issues within set timescales, that would then be actionable as a breach of contract claim in the county courts, and landlords would then be liable to tenants for damages. That civil remedy in the civil courts is on top of the remedies that tenants may be able to bring through the landlord redress scheme. The bill itself is vague as to the specifics of timescales to be afforded to private landlords in investigating and remedying issues. The government, in their commentary, have accepted the fact that social housing providers are very different from private rented landlords. So we'll have to wait and see what any regulations say. But the government has committed to making any timescales fair, proportionate, and effective. There is currently a consultation, or it may have just finished, on what a fair, proportionate, and effective timescale is. And secondary legislation is expected later this autumn. But for now, I think the headline is the inclusion of Awab's law within the Renters' Rights Act means that these requirements will be imposed on all tenancy agreements, so i.e. private as well as social landlords. So if you've got an issue with damp, I would deal with it as soon as possible.
Brill. So, with all that said and done, Charles, what are your top tips for landlords and those advising them in relation to this 226-page bill?
I think my key takeaway is probably proactivity. So just kind of touching on Arab's law, which I mentioned a moment ago, you've got to deal with things as quickly as possible. And the bill is certainly trying to regiment compliance by landlords with certain standards. In an ideal world, landlords should be doing most of this stuff anyway, so dealing with mold, etc. But I think proactivity is the buzzword, certainly in terms of joining the database, joining the ombudsman scheme, and these things are coming in. So the sooner you start to register for them, deal with the issues, sign up to the database, sign up to the ombudsman service, the more that you will be protected. Also, with the fact that there is this cliff edge coming, I think you need to be proactive if you are a institutional landlord or not an institutional landlord and you're worried about these changes, you need to be proactive now in looking at, are we at the end of a fixed term tenancy? Do I want to serve my Section 21 notice now? And you need to be proactive, and I would do it as soon as possible rather than waiting and being caught short by this act coming into effect. I think with that rush to get Section 21s through the door and the influx of Section 8 evictions that will be coming, you're going to be facing a long backlog, I would have thought. So I would try and beat that rush by going in as quickly as possible. I think wider, and perhaps not necessarily a legal issue, but I think in a kind of wider perspective, I think we'll see a drop off of non-institutional landlords. I think non-institutional landlords are getting spooked by the act. And I think there will probably be a release of housing stock, especially at the lower end of the market, which is obviously great news for first-time buyers, but less good for future tenants as the amount of rental properties decrease. Conor, do you have any thoughts?
I think you're entirely right about proactivity. I think so. We now know what this bill is going to say, and I think a couple of the questions were about: do we think it's going to be changed? Do we think it's going to actually come into force? Yes, is the answer to that. This will be coming into force. The Labour government has this as one of their manifesto commitments, and they have, as we all know, quite an extraordinary majority at the moment. So this is going to become law, and I would be very surprised if it doesn't become law in almost exactly the format that we've currently got it, because I can't see the House of Lords putting up a fight in terms of any of these provisions and trying to change something that's a manifesto commitment. So it is coming in, and we know roughly, if not exactly, what it's going to say. So now is the opportunity for landlords and letting agents and lawyers advising them to start planning and preparing for implementation day. Because when the implementation comes in, and we'll talk about that in a second, all of these provisions, including the rights of tenants, but the obligations on landlords and the significant criminal and civil penalties for non-compliance, are going to bite. And so if a landlord or a letting agent hasn't done the groundwork in preparing for implementation day, then there is significant risk that they will be caught short and will be suffering as a consequence. So routinely and regimentally going through every one of your tenancies, if you are a private individual landlord who's got one, then simple, go through the bill and make sure that you are ready for compliance in respect of everything. But if you are an institutional landlord, it's about putting in place systems to make sure that you are not going to fall short on any of those things. And prior planning and preparation really is the key.
all that leaves me to do is thank Conor and thank you for inviting me to come and speak with you today on this interesting topic. You've got the contact details on these slides. I think the slides will be shared after this and will be circulated to everybody. So you've got them. Enjoy what's left of your lunch break and look forward to hopefully seeing some of you in the near future.
Thank you all very much. Thank you, Charles, for agreeing to come and talk with me today. It's been fantastic.
Perfect. Great. Thank you very much.
Thank you, everyone.